Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay, let's go to the 11th Circuit. Let's go down to Florida. Now, this is a really long decision I'm going to make. I can summarize, but this is really interesting. I'll explain the issue, but this is really interesting because what people need to understand here is the court says we are split. So in law, for our viewers, we have something called stare decisis. We have to follow the law. We have to follow the precedent. So there might be a statute which gives law, but then there's interpretations of the statute. And because it's an interpretation, courts can vary on their interpretations. Here, we have higher level courts admitting that throughout the nation, there are different ways of viewing the law, of interpreting the law. So the question here is, we have a retired Florida firefighter who says that he was discriminated against as a result of a disability. Very important to note disability discrimination, because as the court says at the end, a disability is not a protected class. So that gets rid of a lot of other laws where somebody could sue on the basis of gender, race, things like that. So disability here, the way they sue is saying, listen, I was discriminated against in my employment. However, this firefighter is retired. And this firefighter claims that he was discriminated against.
It's a she. It's a
she. I'm sorry. She was discriminated against in her post-retirement benefits. So the court has to wrestle with the question, as other courts have, simply put, does the ADA protect retired employees, right, in terms of discrimination? And this court holds, no, the law does not protect retired employees, but it recognizes other courts do believe the ADA protects retired employees. This is why this case should go to the U.S. Supreme Court and may very well do that. At some point, the U.S. Supreme Court, when it sees the courts of appeals disagreeing with each other, has to say, okay, I'm going to step in for judicial economy. For a lot of reasons, I'm going to answer the question. This is a great question because it keeps repeating itself to go to the U.S. Supreme Court and be decided.
Yeah. And I'm going to tell you, I think the U.S. Supreme Court is going to decide it the exact same way the 11th Circuit did, which you could argue is not an employee-friendly decision. It's an employer-friendly, but I think it's the right decision. It comes down to the definition of who can sue under the ADA is a qualified individual who can perform the essential functions of the job,
right,
without an accommodation. Well, she's not an employee and she
right.
can't perform the essential functions. So there's a lot of different ways that this court, as well as the U.S. Supreme Court, could rule in favor of what the 11th Circuit decided here.
And what I think the U.S. Supreme Court would say, in addition to that, is the legislature can fix this. Congress could fix this. If Congress wants to protect those with disabilities as a protected class, which this court, I think for that reason, pointed out, right, says that being disabled is not a protected class. There's a law that protects you while employed, but it doesn't protect you post-employment. Now, I had some other arguments, I'm not going to get into it, that I might have gone the other way on, saying, well, these benefits are generated, right? They're earned when you're an employee, and but
we get into a discussion in LinkedIn, I believe, on this issue, and someone was raising a question about whether or not Title III and Title II and Title III of the ADA might apply. The government services is Title II, and Title III is public accommodations. And, apparently she didn't argue that, which, maybe it's a procedural error, I'm not sure. But bottom line is, under Title I of the ADA, which is employment discrimination, she really doesn't have standing to bring the action.
Right. And look, so Congress, maybe they'll solve it. Maybe they'll make disability a protected class. That makes sense to me. There's probably someone way smarter than I am to say why they didn't do that in the past. Maybe they didn't need to, but here's a hole, and Congress can close the gap.
You know, they might have thought they did. They had Title 1, 2, and 3, and they probably figured between the three of them, we've created that class. But the definition of employee, or who is subject to the ADA in terms of being a potential plaintiff, leaves a gap there for people who are not employed.
Right. So what people should recognize is this is a big hole, maybe, depends where you are and which part of the state or the nation you are. But okay, let's why don't you go on to Washington?
Right. Well, one more thing with this, it really doesn't get to the merits of her claim, because if you get to the merits of her claim, the question is, when she was hired, the agreement that she had when she was hired was you get health care until age 65. And then at some point, I think it was 2005, if I'm not mistaken, or 2003, they reduced it to 24 months after you retire. And she was alleging that that discriminated against her based on her disability. And I think the merits of her case, I don't see her, even if she could sue under the ADA, I just don't see that as being discriminatory. It was unfortunately,
applied to everybody.
Yeah, I mean, changes in pension programs happen to me during the course of my career as well, and not to my advantage. So they rarely do. But the bottom line is, if you retire before the change goes into effect, you have an agreement, and then it's a breach of contract claim. But I just don't see her prevailing. Even if she could sue under the ADA, I don't see her prevailing.